Good morning, everyone. We are here once again at the Insol's breakfast to discuss the current trends of insolvency and restructuring in Portugal. We're fortunate to have the possibility to discuss these issues with Justice Fátima Reis Silva. She is a complete expert in these issues, justice from the Second Appeals Court. She has a long track record at the first instance court in the Court of Commerce of Lisbon, and also publishes several papers and essays on this matter. My name is Sequeira Dinis. Some of you may know me. I'm also I had restructuring at the Uria Menendez law firm in Lisbon, and I'm kind of interest party in these issues. Without further ado, I would like to try to bring this conversation to Justice Reis Silva, and I will ask her one first question. Now, as you know, hopefully we have, and this is a question, a fairly good transposition of the EU Restructuring Directive in Portugal. And now we have a framework that will be enacted in April this year. And the first question that I would like to place is, one, do you see these amendments to Portuguese law as something that will be that will contribute to the swiftest procedures in Portugal? Do you see the restructuring procedures being more expedited, more complex? How do you see this?
Thank you so much. Good morning, David. Let me thank you for the compliments and the description on my career. We have worked a lot of times together in our different roles, so we've known each other for a few years now. And it's a pleasure to be here and with you in Sol Breakfast. We have a fairly good, I would agree, we have a fairly good transposition law. It could have been more perfect if we had more time, if we didn't have COVID, but I think everyone can complain about that. We didn't we could have started work earlier and so on. But we do have a framework. I think it has the ability to perfect our preventive restructuring mechanism. We do have a very good implemented preventive restructuring mechanism. We do have that in our favor. It has a lot of features already, peaceful, swift, and efficient. It has several issues it has to be perfected. Let me be completely honest with you. In the first times, we'll have some problems. We'll have to deal with the classification of creditors, which is a very strange concept to our system and to our law. We have to deal, in some cases, yes, in some cases not. And we do have some new perspectives. We'll have to have a bit of a different mindset. Everyone, debtor, creditors, lawyers, insolvency practitioners, and judges. So yes, it has the ability, but I think we'll have to work a lot in the first times, during the first. And let me tell you that we only had a vacatio, a 3 months vacatio, which already has been useful because these discussions have been taken in the forums, very useful to this path we'll have to take until we have a more efficient preventive restructuring mechanism.
Let me pause you in one of the points that you raised. So in respect to the transposition of the directive, I see my view is that, I think it's kind of a general view that most of our peers share, is that there was indeed almost a surgical transposition because we already had a very very good schemes of arrangement in Portugal. One of the key features of the new framework will be, for sure, a classification of credits, and feel free to refer any comments that you may have in that respect, but also the need of the insolvency manager, of the insolvency practitioner to take a position on the viability of the company. And secondly, the fact that for the first time, the courts will also be involved in that assessment. And in my mind, that leads to three main conclusions, three main findings. One, I doubt that we are all prepared to take that step. It's kind of a quantum leap in terms of where we are and what we are used to do. And most of us, myself included, what I am prepared to do. Secondly, this will for sure entail that all restructuring procedures will need to be more serious, in the sense that real consultants will need to be involved. Real good lawyers will need to be involved. It will be harder to do with what sometimes happened in the past, which would be just the debtors and the lawyer would get together and draft the plan, and let's see how it ends. And third, it's also going to be interesting to understand what is going to be the reaction of debtors in relation to this new framework. Because there will be a competition, at least for some time, between the PER and the PEVE. And that will be interesting to understand, but the floor is yours.
Let me start by the last point. It was important that the transposition was made by adapting our successful scheme of arrangements, because we can't have too many instruments, because it's confusing. We already have a few. We have this special COVID scheme of arrangement. We have the totally out of court scheme, which is a little different, and we have this pair. So this was an important decision that was made. The first important decision was this, and I agree totally with it, because. And then I come to the second, to the first question. We'll have to be all more prepared, starting with the debtors. In the past, we've seen, well, in the first years, we know what happened. We had to restructure everyone. We had to recover everyone. So some abuses were committed, but I still have a positive balance of those first years. A lot of enterprises were really recovered. And then those abuses were corrected, because we not only had a successful scheme of arrangements in working, but we had already adjusted it to the new times. And then COVID came. But that's history. We can't do anything about it. We can't do anything about it. And the use of our scheme of arrangements, which is called PER, both of us have already mentioned it. Our arrangements with the debtor not prepared, with the debtor not talking previously to its creditors, with the debtor not looking at it himself before, was something that used to happen, and now happens a lot less, and now it won't happen at all. The classification of creditors has this consequence for me. The debtor has to know profoundly his creditors, and sometimes they don't. I think you're in the ground, you're a lawyer, you know what I'm talking about. Sometimes debtors are surprised with some creditors that arise in the procedure. This cannot happen. This should never happen. This should never happen in the business world. So it should never happen in court when we're trying to recover. Are we all prepared? We'll have to be, because this won't work if we are not prepared. All restructuring procedure will have to be serious. I agree with you. Personally, we have an abbreviated procedure. in which the debtor and its creditors reach an agreement and bring the agreement to court. And this is what we call the small pair. And for me, this is the serious one. This is the real one. This was the one I've seen being successful because everyone is prepared, has done his homework. The negotiations are serious. I know not everyone can do it, but in its scale, small, medium, and big enterprises, this was used measure by big enterprises, but it can be used by small and medium enterprises and micro enterprises. In its scale, can be used. It is serious. You have to work before. You have to work a lot before. And then when you come to court, you do something which is essential to the success of this kind of hybrid procedure. You take a lot of decisions from the judge's hands. The least the judge intervenes, the better it will run. And this takes me to one of the points you mentioned. The classification of credits will be a big challenge for us, but the feasibility test, the feasibility evaluation will be surely one of the biggest problems, challenges, and merits of this transposition. I'm a commercial judge for 16 years now, something like that. I've been dealing with insolvency, bankruptcy, and restructuring. As long as I remember being a judge, I have never evaluated the feasibility of a plan. Never. I don't even know how to do that. I have some ideas, but this is something that can't be done with some ideas. Okay, so this is what I was talking about. Insolvency practitioners will have to learn to deal with this. We'll probably have to make some changes in the profession because of this. We'll have to create classes of professionals. We have to create experts for this. People that can come quickly to court and help the judge decide this kind of matters. And judges will have to invest more on its education. And this gives a new sense to a big movement of specialization that has been occurring in our country. You're rather young, David, you're younger than me, but you'll probably remember when we didn't have that much commercial courts and what it was for someone like you, a specialized lawyer. I know lawyers are not specialized, but you know what I'm talking about. A specialized lawyer to go to a common court to discuss with a common civil judge a big case of preventive restructuring or even corporation law, wherever these matters. It was different. The scenario now is different. I think we have the tools. We have to create a few more. I think we'll get there.
Well, I agree. Well, it's not because I'm talking to you. I've said this in the past 20 of times. We are very lucky that we do have very good judges in Portugal that are very motivated. But I fear, and this is my biggest concern, is that this will not only rely on the individual judge's motivation to learn, but also on government making what it needs to be done to have all the resources and all the tools. And because we cannot rely, this is a problem that we probably have in general in Portugal, we cannot rely on individual qualities, but because that will create a situation where in court A, you have a very good judge, and in court B, you have a less prepared judge. Not because he's not motivated, but because he simply doesn't have the background, he doesn't have the support, etc. And you were referring to this. Yes. And I remember perfectly two big cases that I had, one in the Alentejo and another one in up north, where in practice, the final judgment was not awarded by the judge, but by the expert. He he asked for help. Do you follow me? So, and I need to be clear on this and respectful to the extent that those particular judges who were not in specialized courts they were humble enough to ask for help. But at the end of the day, that cannot become a trend. We need to have specialized judges, and probably we will need to send a lot of these current judges to school again to learn finance, to learn economics, accounting, and that will be a big effort. But I'm confident that will turn out okay. But I think we need to accept as a country that this has been a major change, and we cannot only rely on, as we did in the past, that people will individually solve this. Do you follow me?
Yes, this is a theme that is quite dear to me. A system can't rely on individual characteristics of the persons. A system has to have its own solutions. So, for instance, the feasibility evaluation, the judge can ask for help. The judge should ask for help. We do have to implement a framework that gives the judge the help it needs. But in the end of the day, this is the decision of the judge. I say this a lot to the young trainee judges. I don't know how to do a balance sheet, but I can read it. So this is it. I don't have to go to economic school. I don't have to be a manager. I just have to know, what are you talking about? This is essential for me. So this can depend on my will to get educated or on my interest on financing. We'll all have to do this. So the framework must exist. But in the end of the day, this is a judge's decision, and the judge must be educated. We all have to go back to school. Yes, but we are still judges. So this will still be our decision. It won't be the expert's decision. And the use of experts is also a problem which our law did not really address. We have the directive. It's true. Because I think we all know, for instance, that we can use expertise, experts as we review, as we use it in civil procedure, because the company can't wait that long, the procedure can't wait that long. So this for me is an essential point. A framework has to be created, implemented, that will give swiftly to the judges the help they need. We can start by insolvency practitioners. At this point in time, I think the only experts we can call upon will be insolvency practitioners, other insolvency practitioners. But in time, will probably this need will other fields, like in competition law. The need created the expert. So this will probably be something that will be implemented swifter than we think. It's basically a problem of system implementing the framework and then mindset for everyone.
Let me just direct two last questions. So one is, how do you view I find it very useful, and because we simply did not have any real protection for rescue finance, etc. So that was a big change. So I wanted to hear your thoughts on that. And I think that there are points that should have been made clearer, but one should praise the change. It's very helpful. That's one point that I wanted to hear you on. And the second one would be, and this is a tricky question, it's going to be on how to vote a restructuring plan. If you can give us some leads, because there are plenty of discussions happening as we speak. I've been to plenty of forums, and people don't simply, well, probably, I don't know if it's the people's problem or the law, but there are different interpretations, and we cannot go back to a system where there are multiple interpretations of such an important point in the framework. So, but again, please.
So that one was really a trick question. I don't know if I'll get there, but let's talk a bit about financing. This is a very important point, because the years showed me that this is the major cause for plans approved not to be successful. The success of a restructuration plan depends heavily on financing. Everything else can go okay, and if this doesn't, nothing will happen. And so this the clearing, the setting, in two major aspects. We have enlarged the new financing and the interim financing. Our law has not defined interim financing and new financing, and this means, like in a lot of other issues here, we'll always have to go to the directive to interpret our law. And this is also important. We do this in a lot of areas of law, but it will be critical in the implementation of this reform. So everyone will have to get used to go back to the directive and then go back to our law and interpret it this way. This may seem obvious, but sometimes it's not. So, for instance, we did not define the directive as defined interim financing and new financing. We do have executory contracts, which is an area that has to do also with interim financing. We have some warranties which have been enlarged. Very, very, very important was the enlargement of the privilege given to the new financing to equity holders. This is very important. This is a big incentive to intern financing, which will be probably the one that is available. Yes.
But just let me pause you there. But one question: don't you think that the way, literally speaking, we have two types of protection to new financing? Okay.
Yes.
There's one that gives the borrower, the lender, a possibility of having a claim against the insolvent estate in a future insolvency. Yep. And then you have another one that basically replicates what we already had, which is a special privilege. But the law allocates this first protection only to creditors per se, and the second one encompasses not only creditors but also shareholders, etc. In my view, this discrepancy doesn't make much sense, and it would extending that. So making sure that the first protection would also be available for shareholders would not breach the directive, in my view. There's no literal, the directive does not literally block that. The spirits underlying, the logics underlying to the directive also do not block that. And I really think that we should take it as the next step. That would be one question. And another comment that I have is the law says that only creditors have the benefit of this first protection. And I'm strongly advocating for expanding that word creditors to include third parties who are not creditors in the proceeding per se, but become creditors later on. Because if we sustain a narrower interpretation of the law, what we will be excluding new lenders coming in. But sorry to interrupt you. Just to try to
no. The questions you're asking are the soul of what we're talking about. These steps we gave are still small steps. It's better than what we had before, but a lot still has to be done. It's not perfect. It will not solve the problem. That's what you're telling, and I agree with you. But we have to go by baby steps. And for instance, concerning equity holders, there's a lot of prejudice, which I also feel in the directive against equity holders. And so this was a very important baby step given here. Maybe the next one should have been taken, because that's where most of the money comes from. We do know that. We do know that. In this time, it won't come from nowhere else. Yes, probably we should have gone far. Yes, I agree with you that probably the directive does not forbid it. The directive still, I feel a bit of prejudice against equity holders in the directive, not concerning this part, concerning other parties. Yeah, I think we agree on that too. Maybe it's justified. I don't know. I don't have that. This would be another talk. I do not, after 16 years of practice, I don't have that prejudice, really. The cases that everyone talks about are really very narrow cases.
It's the exception.
Yes, they're the exception. But then that's a talk for another day. Yes, we could have gone far. No, this does not solve the problems. And also what we had here is better than we had, but still has a few problems. For instance, we've chosen a percentage of the credit. We did not choose to give privilege to a percentage of the credits. We did choose to give a privilege to a percentage of what will be the creditors when the insolvency will be declared. And this is lack of security. When you want to give credit, you must be able to sit down and make the math.
Like me.
How much? And this is not.
I'm currently preparing several.
This is difficult. Yeah.
Several fairs to be filed after the new law will be enacted. So I'm experiencing the problems looking at the loopholes, etc. And obviously, one of the first questions that clients ask are, well, but how do I calculate those 25%?
Yeah.
And no one really knows. Obviously, my answer is we need to look at today's balance sheet, but in 2 years' time, it's impossible.
Well, let me interrupt you there, which is not really the problem. How are we going to solve this in concrete? The problem is that creditors, which are willing to financiate, will look at this and see a problem, right?
They are already looking.
Yes, that's already. And this is the kind of things we should avoid. Not easy. This is not easy. I know there are other solutions in other laws, but also solutions which are not perfect. We could have chosen the list of creditors. This would not solve the problem, really, and would give maybe a not fair portrait of the future of the company. Will also create other prejudices. I'm a judge. I can criticize. I don't know how to make a better solution for this. But let me still go to the approval of plans. The Portuguese law made a choice. Let me say that we already had cross-class cram down without cross-class. Cram down for us is as natural as breathing. We have no problem with that, none at all. No debtors, creditors, everyone is used to this. This is what the judge does. The judge forces a plan against everyone who is not in agree, as long as we have a majority. This is what we do since we have this restructuring framework. So we're used to this. This is not a big deal. Classes will be a big deal. So probably because this is not a big deal for us, and this is the kind of decision we used to make, and this is the kind of decision that we used to accept, to challenge, and so on. The Portuguese law made an option, which may seem strange, was to congregate approbation and confirmation, which in the directive are two very separate stuff because of cross-class cram down. In our law, was made, I think, in just one phase, and that's one of the problems with the counting and how do we approve or we do not approve, because some stuff that are in the directive as conditions of confirmation are conditions of approval in our law. So when the directive says this is not approved but can be confirmed, we do say this has to be approved. But to be approved is like when the directive says to confirm. This was an option. I think it is allowed by the directive. I think this is still a transposition of the directive, but it gave us a very large text of the law and some confusions and probably some words less or more. I already heard there's a lot of discussion because of one word or, and that's one of the reasons I say we'll have to walk this path very slowly and think a lot about this. I think it's feasible. Sincerely, without having any case, I think this is completely understandable, hard maybe, but we're already talking about decisions that can be appealed. If the approbation can be appealed, and today can be, the next one will be too. And most of the cases will have to do with the classes of creditors. With the cases where we have classes of creditors, we won't have classes of creditors in every case. We won't have classes of creditors in the majority of cases. That's my conviction and the conviction of, I think, almost everyone. So in those cases, we still have the feasibility evaluation. This is obvious. We still have some differences. We still have a slightly new procedure. We still have to have a new mindset, but we won't have classes of creditors. And so the approval will be much more simple, which will be much closer to what we had. But I won't finish this without saying something. Classes of creditors are an element of justice. This is harsh justice. We had a majority that would impose on everyone, a majority of creditors. And what we do, theoretically, I know in the end of the day, sometimes things are not like that. When we choose the system of classes of creditors, is to give the word to everyone, is to level a bit the floor. It's to level between the banks, the credit institutions, and the workers. It's to level their position. And this is justice in action. And this appeals a lot to my sense of justice, although I know it will be difficult.
Well, justice.
I've not answered your question.
No. Well, this was a wonderful conversation. The fact is that we have expanded over our time limit, but it was very, very useful conversation. I thank you for your participation. And thank you. I'm sure we'll meet again shortly, and I will invite you for another coffee break or INSOL event to make sure that we keep up with these conversations. Thank you so much.
It will be my pleasure. Thank you so much, David. Good morning, everyone.